No, I was doing two things at once. All right, Alton Brown's warrant is issued, his probation is told. All right, Ms. Chambly is virtual, I'll come back to her. That's good. Lindsay Corbett,
Here.
thank you.
Patrick, did you be involved in that case? Did you want to ask me?
All right, Mr. Davis is here. We'll come back to that one once Mr. Shepherd's had a minute to talk to people. Elliot, Porter is currently a no-show. Conflict letter is a question mark. Bradley Fletcher.
Here.
Thank you. All right, that's page 2. Adrian Freeman.
Charles Mann for Ms. Freeman, Your Honor. May I approach briefly?
Sure, come on up.
Your
All right, that's a warrant. All right, as fresh as warrant is issued, his probation is told. Faith Geddes.
Here.
All right, thank you. Jeffrey Gilbert. He's usually in jail.
I'll check again, but I went through it yesterday and he wasn't in jail.
I didn't see it either, I'm just,
Judge, due to the high nature, I mean, this is not a high and aggravated, but we're all familiar with this case, and he's absconded and nothing's done. I'd request a no bond on the warrant.
great. All right. I'm just pulling the census just because I usually know exactly where to find it.
No, sir, he's not.
Okay. All right, Jeffrey Gilbert, 21 SR 596. Warrant is issued, probation is told. No bond. Okay. Calvis Grant. Calvis Grant.
Case is off, Judge. I apologize.
William Gregory?
Here.
Wonderful, thank you. Go see. Nicholas Harris?
It's not a probation case, Judge.
No, it's not waiver. Nicholas Aaron Harris? No? All right, it's 9:44. I'm gonna deny it, as he is a no-show. He's welcome to file again. Sinatra Hill? Hill? No? All right, issue warrant. All right, Hill's warrant is issued and the probation is told. Dontavius Johnson? Johnson? No? All right, 21 SR 1259, issue a warrant. All right, Johnson's warrant is issued and the probation is told. Jeremy Kaler?
Here.
Excellent, thank you. Jared Kelso?
Here.
Excellent. All right, Ms. Mabry is a consent and is finished. All right, Mr. Smith, this is a jail case. He's back talking with Mr. Malloy. Oh, I skipped, sorry. No? I somehow lost my page file. I should have just used the copy Erica gave me because it's in that one and it's not the one I created.
You copied this?
No, I did that to myself. I have no one to blame but Josh Thacker. Heather Maddox?
Here, Your Honor.
Thank you. Okay.
It's a current probation case, but there's some documentation where she's met with Patrick. And she's going to amend it.
Are you wanting, if you're successful, Ms. Maddox, what are you wanting me to, in 5 seconds or less, what are you wanting me to say?
I'm wanting you to dismiss all charges.
Okay, that's fine. I just was trying to understand the scope of what you're trying to get me to do.
Yes.
All right, thank you very much. Andrew Maynard?
Here.
Thank you. Jesse McMullen?
Here.
Thank you. Reginald Miller?
Here.
Excellent. Jamesia Litton?
That case is off, Judge.
All right, now we're on Fulton Smith, who's back talking to Mr. Malloy.
We'll just do some logistical stuff right quick.
That's fine. Sarah Smith?
She's here.
That's the one
That's,
where?
that's my case, Judge, and that happened today.
Perfect, great. Shamir Walker?
The case is off, Judge.
Mr. Johnson? Mr. Malloy said he needed to speak up to you. I think what I'm gonna do, well, I guess that one, that motion dismisses yours, I guess.
It's
Okay. I'm just gonna call her up and get context.
Yeah, I got some notes where she told us that she met with,
Okay.
and then she's filed this motion. I made you a few notes. She was sent on January 17th.
Why don't we do this? Why don't you go, Mr. Morris, he leads out, and, yeah, I'll talk to her, figure out what's going on. And then when we come back, we'll, set him in, it's gonna be a full chair, so the workers, so they're ready, we'll submit to that.
And I don't really know you know, talk about this case at all, but just for context, there's been no payment.
But everybody else is.
We're up to the third.
And I'm just gonna try to get some more context. Okay, Miss, Miss Maddox, come up to the podium.
You are?
I'm not taking questions from the crowd, but you can speak with the bailiffs. They're very good at what they do. Oh, are you in the wrong courtroom?
No, my name, Miss Matthews, my probation.
Yeah, we're up in this civil case.
Okay, so I'm not supposed
Yeah, the bailiffs will tell you which way to go. And we'll vouch for you that you were on time to the wrong court. So if you'll step out in the hallway.
Here, there.
Either way, doesn't have to.
Set myself up. Second. Okay.
All right. The court calls 22 TK 4801 Heather Lynn Maddox. Ms. Maddox is here on her own motion. Which was filed on February 17th of this year with the clerk of court, asking me to dismiss or remit all charges due to the incorrect information on the citation and lack of significant evidence against me. It says, I'm asking that the judge consider this and give grace upon me and dismiss all charges. Signed and dated, Ms. Maddox, and the clerk has set it for court today. All right, Ms. Maddox, I'm reviewing your file as we're talking. You entered a plea with me, it appears, is that correct?
I did.
Okay, if you will pull that microphone up and fill me in as to what it is you're looking for and why it is you think I should grant it. So what are you looking for and why do you want me to grant it? And why do you think I should grant it?
So I received a ticket for speeding on the date of October 20th, 2022. The officer said that I was speeding in a 35 zone.
Okay.
I didn't think that it was a 35 zone. He stated it was. After doing research, a lot of research, I was correct that it was not a 35 zone. It was a 45. And I have proof from the Public Works Department, statements from them proving that there was no 35 speed limit sign there. When I received the ticket, it was 45. So I believe that my ticket should be thrown out completely, as well as he stated that he used a laser. When you use a laser, you have to be in a stationary position. The officer also asked for for footage, and I reviewed the footage, and the officer was pulling out of his driveway when he pulled behind me to pull me over. And, I even reviewed the camera where, there's, an alarm where it shows you're braking and, with the lights where you, sorry,
Okay.
I'm not an attorney.
I'm
But
listening.
I am, you know, you have to be stationary when you use a laser. You have to be parked and you have to be using your hands to, you know, to hold that laser and he was not. And he stated in his, in the ticket that he shot me with a laser. It's impossible if he's pulling out of his driveway, pulling in behind me to shoot me with a laser. So that's also false. And I just feel that if I was speeding, okay, I was speeding, but be truthful about it. Let's not put ludicrous in a ticket just to give me a ticket. And I feel like I've gone to great lengths to prove that this is false.
Okay. And
And I have proof from the Spalding County the Public Works Department going back to 2019, September 2019, proving that there was that there was a speed limit of 45 in that area where I was pulled over back in September 2019. So, and I have the work order that they had as well, that she printed out for me.
so if I'm hearing you correctly, you're saying that when the citation was issued, the officer was in motion,
Mhm.
using a laser.
That's what
And-
he stated, but
Yes.
he was not.
Okay.
Because I had open records request, and I asked for I got his body cam footage as well as the vehicle footage.
And the footage you're saying you called showed his vehicle to be in motion.
In motion, absolutely. Pulling out of his driveway. And I also asked for, I called for dispatch where he clocked in to prove that he was pulling out of his driveway, not just stationary parked somewhere, like clocking, like shooting laser or trying to clock speed.
Okay. I guess what I'm confused about, and I would like you to address, is if, assuming these things to all be true, these would all be valid points at a bench trial, but you chose to enter a plea and close your case. So help me understand that disconnect before me, which is that this would have been a great bench trial, or jury trial. You could have had a jury trial. And I would have certainly been very interested in those questions, but you entered a plea and closed your case. So why should I undo a plea that you entered? So take 5 seconds and answer that question, please.
I'd love to. I was the last person before everybody went to lunch. I was actually in there doing the counsel. I've never been to court before. This is the first time. I was the last person in there. Didn't know what to take, didn't know what to choose. I figured the worst case scenario for my situation to keep the least points on my license was to plead a NOLO. That would be the best for my situation. I didn't know, that was the best for my situation. Didn't want to do it, and you were about to leave, so I figured that's just what I had to do. Actually, Patrick came in and said, you're out the door, so I had to pick something. Honestly, just being very honest, and that's why I chose that. And then I was not happy with it, So that is why I chose to come back and file a motion. Didn't know which much, I would, if I need to do this over again somewhere else, then I would be happy to do this again, if that's possible.
So you were here that
But-
afternoon of Tuesday, January 17th. Okay. All right.
Because I think I had a 1:30 appointment, but I came that morning instead. And I was
Oh,
the
okay.
last person before y'all went to lunch. You saw me last.
So you came at the wrong time and we handled your case out of turn.
Mhm.
Okay. All right. Anything else you want me to know as I evaluate your request?
Well, other than that was, and this is just silly, but that was the day I wish y'all showed up for court when all our houses got blown down by a tornado, and not many people showed up for court, but I did show up for court that day and showed up early, and just the fact that I made an effort and showed up anyway, and here I am showing up again and going through this great length to make an effort to prove my innocence and, right is right and wrong is wrong kind of a thing.
Okay. All right. Thank you for that. Anything else?
No, sir.
All right. And the look you see on my face is me thinking through the procedure of this request. So here's the options on the table for me. I can simply deny your request. The standard for withdrawing a plea is to correct not just a regular garden variety injustice, but a manifest injustice. So I have to find that a manifest injustice was committed against you in this courtroom before I am required by law to allow you to withdraw your plea. The second issue is that I need to review your plea, review the paperwork, but I'm also planning on reviewing the record of the plea as well to confirm what was said. And so I'm going to take this under advisement as far as today goes. But in the meantime, while I'm thinking about this and reviewing the record, I'm telling you right now that you are still under probation. That is not told, it is not stayed, and you must participate in that process, or I will issue a warrant for your arrest. Do you understand that? Okay, because you made that commitment. You said you would do that. And the last thing Ms. Matthews said on the way out the door is that there have been multiple missed appointments. So maybe there are, maybe there aren't. But it's my job to say very difficult things out loud. So let's just assume that there aren't. Let's assume Ms. Matthews is wrong. I'm just telling you, just as a heads up, if you miss appointments, I will issue a warrant for your arrest. Do you understand that? Okay, so that's not why we're here today. It's just me giving you a heads up as to your roadmap moving forward while I take this under advisement. Okay? Again, I'm not saying you have or haven't missed appointments. That's not on the table today. It's just me communicating very clearly with you about what I'm going to do if you don't follow the directions that I'm giving you. Fair enough?
Can I ask you a question about that?
You can, but
So the JAG cancel thing that I did when I did the NOLO, so I had a conversation with the nice lady who was dealing with that. I had a conversation with her. She said that that was being moved over to the monthly thing. I haven't heard from anybody since that.
that's what I'm telling you, is that they're saying you haven't come back. And I'm simply saying, I don't care whether you have or haven't. I'm telling you that you need to report to probation. You're gonna report to probation tomorrow. And it's behind the Burger King on the opposite side across from TBS. You have a report sheet that they gave you at the time of your plea. But it's JAG, English Alternatives of Georgia. And again, I'm gonna take this under advisement. I'm gonna listen to the record that Ms. Kathy made on that day. And then I'm gonna issue, do we have a good email address for you? Because I'm gonna issue a digital order, and it's gonna be emailed to whatever email address we have on file.
Can I verify that privately
Yes.
with?
I'm pulling it up right now.
Okay.
All right, what's your, hold on.
Yeah.
All right, what's your email address?
Can I approach?
No,
You can write it down.
yeah, you can write it down if you want. Oh, I'm remembering you now. You kept trying to come up and talk to me during the plea, and I kept saying no. I just had a flashback from it. I remember your plea now. You kept trying to come talk to me, and I kept saying, no, you cannot come up here and talk to me.
I'll be an attorney one day, you just wait.
Yes, ma'am. Report your probation tomorrow. All right, you're free to go. You'll receive my order in your email.
Actually, I don't. Oh, my God.
That's Ms. Maddox's motion to dismiss. It's under my.
She good to go too?
Yeah, you're free to go. Thank you.
All right, thank y'all.
Thank you.
Nothing else changed.
No, it's choose your corporation tomorrow. When it's changed, that wasn't there. All right, Mr. Smith, you can sit by your attorney. All right. All right, you all are both under oath. I've already sworn you all in when I started this hearing and we adjourned it to do some other matters, and now we're circling back to it. Mr. Malloy, after speaking with your client, can you let me know whether or not this will be, are y'all ready?
Yes, Your Honor.
All right, and will this be an admission or denial or an admission with argument about
Now, Your Honor.
denial across the board? Okay, so with that said, Mr. Shepherd, will you be representing the state in this hearing?
Yes.
Okay. So then at this point, I will simply say that defense is ready. Mr. Malloy is representing Mr. Smith. The state is here. Ms. Matthews is on the stand. Everybody's sworn, and we're ready. So, Mr. Shepherd,
Is your other witness still in the court?
are there any witnesses?
Yes.
Scott?
She's right there.
All right,
You
ma'am,
want to
if you will step, you want to step out. Okay, they're invoking the rule. That means I can't have witnesses in. There's some seats right outside those two double doors. If you'll sit on those, and we'll bring you back in just a minute.
Get you just out.
All right, Mr. Shepherd, of course, yours. Anything else?
All right, state will call Marty Matthews. We already swear her in.
Yes, I did.
All right, Ms. Matthews, can you state your name, please?
Marty Matthews.
And Ms. Matthews, how are you employed?
I'm the Chief Probation Officer at JAG Probation.
All right, and are you one of the probation officers for Mr. Fulton Smith?
Yes.
All right, is that Mr. Fulton Smith sitting here at the defense table?
Yes.
All right, when was Mr. Smith placed on probation?
These cases actually originated 21 SR 0118. He was sentenced on April 21st of 2021. And then 21 SR 1684, he was sentenced on September 7th of 2022. The first case was consecutive to 20 SR 1672, and that case didn't close until September 21st of 2022. And that's when this one actually began.
Okay, so 1684 and 0118, those began when? The time for-
1684 began on the day he was sentenced, which was September the 7th of 2022. And 21 SR 0118 began when the previous case, he was released from jail on it, which was September the 21st of 2022.
Okay, and those are running concurrent?
Those are running concurrent. He was revoked on that previous case.
Now, on 21 SR 1684, are there any special conditions on that case?
There are, he has to obtain his license, he has random drug screens, he has a no violent contact with Charlotte Scott.
Now, you filed a petition to revoke Mr. Smith's probation?
Yes.
All right, and what grounds have you filed to revoke?
Since being released from jail, he's only reported once. He hasn't made any payments. He obtained a new charge of violating the family violence order on or about January the 12th of 2023. With that violation of the family violence order, the victim listed in that violation is Ms. Scott, which he was to have no violent contact with.
Okay, and so as far as him missing report dates, how many scheduled appointments, when you filed this petition, now you filed this back in January, correct?
Yes.
Okay, so as of January 24th, when you filed this petition, how many appointments had he had scheduled?
4.
All right, and how many had he missed?
3.
And he has also had some fines he had to pay?
Yes.
And how much was he in arrears as of the filing of this petition?
$276.
And you also mentioned the new charges, and we'll get into those in a few minutes. So what's the balance left on 21 SR 0118?
Monetary?
Well, yes, that too.
So it's a 12-month no early termination case. It has 248 days remaining. And he hasn't provided proof of his driver's license. The balance on it is $1,917.50. And that's a full 12-month balance if he was to serve the rest of it.
Okay.
And then on 21 SR 1684, it has 234 days remaining. The same condition, he hasn't provided his license. And the balance on that case is $785.
And this is not the first revocation hearing we've had with Mr. Smith.
On these cases it is, but not since, he's been on probation, at JAG probation, or with the state court.
You have any idea how long he's been on probation in total, y'all? You may
Looks
not have
like
it.
he's had 4 cases. The first case began on July 25th of 2017. And then he's had the case that was just recently revoked last year of 20 SR 1672. And then he has the 2 cases in court today.
So he's been on probation off and on with you since 2017.
Yes, sir.
Most of the time, really, since 2017. It would appear.
Let me see the dates. The 2017 case ended in March of 2020, and the next case began in 2021. So there was about a year in between that he wasn't on probation.
And these cases here today, one of them was a consecutive case. The case that was consecutive to 20 SR 1672, that ended in a revocation.
Yes.
All right, and if the judge were to revoke Mr. Smith's probation today, what would be your recommendation?
That he served the remainder of the time in jail to try to protect the victim.
That's all the questions I have for Ms. Matthews.
All right, Mr. Malloy, cross.
Ms. Matthews, so as of today, approximately on both cases combined is 248 days. What the balance is?
That's the longer sentence,
Longer
yes,
sentence.
since they're
That's
running.
234 and 1, so.
Yes, sir.
All right. And so, Mr. Smith, what has been his interaction with your office?
Well, we only have the one appointment, so there hasn't been much interaction at all. I mean, at this point, he had, the warrant was actually signed on these cases back in November because he had completely absconded. And then he was arrested in January because he obtained a new charge. So we really haven't had any interaction with Mr. Smith. Therefore, it's hard to manage his cases or see what his situation is, offer any assistance or anything like that when we can't get him to interact with us.
While we're off record and they're talking, I'm sorry, while we're not doing it, I need this on the record, while Mr. Moore's not listening. What's the status of the new cases that got ranked? I saw there was a court date that came in, but I didn't see a notice of.
No more questions for Ms. Matthews.
Okay.
He has a code.
Has he been arraigned on the new case? I saw an accusation on the file.
It's 23 SR 0276. I don't
I don't see a reset notice.
think he's
I
been
don't
right
think,
on.
yeah, I don't think he has.
Okay, well, let's just make certain we do that before we all part ways. I got everybody in the courtroom, so if you'll just go and do a reset notice for Trump. Okay, Mr. Shep, so back with this here. Mr. Shepherd, are you ready?
No.
All right. Ms. Matthews, I think I may, you know what, why don't you just stay there? We've got that table right there. I have Ms. Scott, we'll use that mic and put it over there. That way Ms. Matthews doesn't have to move all of her stuff. So Piper, thank you for your help. And if you'll give Ms. Scott, Ms. Matthews mic, and I just want to make certain you can see if I put Ms. Scott.
Oh, yes, sir, that'll be fine.
And Kathy, does that work for you?
Oh, I'm fine.
Okay.
Is this a good record?
Yes, we'll just grab Ms. Matthews' microphone. No, that one, yeah, that one.
At the tables.
Is the table there? Oh, Mr. Parker's at the table. I'm so sorry. I just realized that there's no
I think
table.
it'll be okay.
I'll slide around.
Towards.
I'll slide around.
I'll just switch it, put it in place of that one.
I've got leave my.
Judge, I can rotate.
You don't mind?
So,
No, not at all.
Thank you, Mr. Parker.
I was sitting here because the.
I can't see that spot and I totally forgot that the table's not there. Their building is 2 more above the way. So,
The, Griffin PD officer was here this morning was the only reason I was sitting.
Well, well, it's normally not. That's where Major Edson is. And, Williams, let's scoot her down a bit so everybody, no, just the chair towards the end a little bit. So I just want to make sure.
All right, were you getting this, Scott? Yes. Okay, thank you.
Mr. Lloyd, can you see the witness, okay?
Yes, sir.
If you can't, let me know. Scott, I'm gonna have you sit at this seat right here. I've got Ms. Matthews up here, and I'm just gonna leave her be. She's allowed to stay in the courtroom. And Mr. Shepherd is going to be handling this one.
All right, Ms. Scott, before we start, will you raise your right hand so I can swear you in, please? Do you swear the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
All right, thank you. Can you state your name, please?
Charles Scott.
And Ms. Scott, are you in a relationship or previously in a relationship with Fulton Smith?
I am.
All right, is that Mr. Smith seated over here at the defense table?
Yes, sir.
Okay. And are you aware that he pled guilty to a case of simple battery, and as a condition of that sentence, he's to have no violent contact with you?
I was aware of that, yes.
And he pled to that September 7th of 2022. Does that sound about right?
I'm not sure of the dates, but yeah, yes.
All right, so have y'all been living together?
Yes, sir.
So since he got on probation for this case, y'all have been living together?
Yes, sir.
Now, where do y'all live?
We live on Lakeside Road,
That's Spalding County?
Spalding County.
Now, on January the 12th of this year, did y'all get into some kind of an argument?
We did get into a verbal altercation.
All right. What were y'all arguing about?
Him not being truthful with me.
Did it become a pretty heated argument?
I mean, we were just arguing. That's it. I mean, words.
So did it get to the point where somebody called the police?
I did call the police
So why did you call the police on that?
because I wanted him to handle his business. I wanted him to take care of his business. That's why we were arguing.
And so did the police come out there?
They did. They locked him up.
Okay. Did he put his hands on you that day?
No, sir.
It was just a verbal argument?
It's verbal.
Okay. All right. Is there anything else you want to tell the court about this?
I mean, I guess.
All right, that's all the questions I have for Ms. Scott.
Mr. Wood?
Ms. Scott, just very briefly then, so knowing the condition of his bond was to have no violent contact with you, and this day you guys had an argument, but you felt necessary to call the police. There was no problem. Why did you call the police?
I called the police because I knew he had warrants. I wanted him to handle his warrants. I found out that day he had warrants. And I wanted him to handle his business.
Okay.
That's why we were arguing, is because I found out about the warrant, yeah.
But there, okay, well, I'm not gonna have you repeat testimony. I don't think I understand. I don't have any other questions.
Okay. All right. I think I've got my brain around this. All right, Mr. Shepherd, any redirect?
No, sir, Judge.
Okay.
Well, I do have one. Ms. Scott, when the police came, did you tell them that Mr. Smith threatened to burn the house down?
I don't recall that, no, I'm pretty sure I did not say that, but I'm not positive. He did not threaten to burn my house down that day, but I think that what happened was I told the police, because I wanted them to get him and take him and him handle his business. And I said, he has before, but he didn't that day.
I don't have any further questions.
Okay. All right. Mr. Malloy, any recalls?
No, Your Honor.
All right, ma'am. I don't have any questions. Ma'am, you may, you've concluded your testimony. You may step back out into the gallery if you wish. You may leave. You're released from your subpoena, and what you do next is completely your decision. I just want to let you know, you may go out in the gallery if you wish to stay, or you may leave, however you prefer. I'll have you go around. Thank you for that.
Judge, we don't have any further witnesses on this. We'll rest.
Mr. Moore? All right, Mr. Moore?
Mr. Smith, wants to.
Testify?
Yes, Your
All right, you advised him of the procedure and the rights that he's waiving?
Honor. Yes, Your Honor, but could the court, for the record purposes, put it out there just so.
Happily.
Thank you, Your Honor.
Mr. Smith, do you understand that Ms. Leach is taking this down?
Yes, sir.
That's the official recording of the court.
Yes, sir.
And anything you say will very likely be requested by the prosecutor to be used in a transcript at a potential future trial on these charges, which for this purpose is a probation violation that is pending with this court as 23 SR 0276. Do you understand that?
Yes, sir.
And knowing all of that, and knowing that you will be, that I will insist that you speak the truth, the whole truth, and nothing but the truth, whether you like it or not, do you understand that if you waive that right, you will be required to testify truthfully and completely?
Yes, sir.
Okay. I'm gonna find that he is waiving his right to remain silent. Mr. Malloy, we're just gonna leave him where he is. He's got a microphone. You may begin your direct.
Mr. Smith, just tell the court in your own words what it is you want the judge to know in regards to this matter.
Sir, December was frozen, it was frozen, it was cold the whole month. I didn't get to work. I was scared to report. That's why I missed those two report dates. I didn't have the money because I couldn't work. Big pressure washing and lawnmower service. And it's hard, it's hard to get that stuff done in December. But I can go to work now. There's plenty of work to do.
Okay, thank you for that. What else do you want me to know?
I didn't do none of that stuff. And the first time I went to court on the first case, they took me to court a day early. I didn't know. I thought she was supposed to testify then, and I didn't hear her on the first case that I got. But they took me to court a day early, and I thought I couldn't get out of jail unless I pled out. I thought she didn't show up for court. And that's why I pled out the first simple assault. But that's past. I can't, I didn't do nothing sort of, I don't know.
You talking about the plea you entered in September?
Yeah, no, the one before that.
All right. Mr. Malloy, any more questions for witness?
No, Your Honor.
Mr. Shepherd and Cross.
So, Mr. Smith, did you fail to report to probation?
Yes, sir, sure did.
Did you fail to pay your fines?
Yes, sir.
No.
I got the money now, spent at it.
So on January the 12th, did you get in an argument with Ms. Scott?
Yes, sir, I did.
Yeah, argument.
Just a verbal argument, we didn't, wasn't nothing bad.
So did the police get called?
Yes, she called.
So it got heated enough to where the police were called?
No, she called and wanted me to go take care of my probation problems. It was, told me when I left, she said, I'm sorry, but you got to take care of these probation problems. Get took up. That's what I'm trying to do.
And you were aware you weren't supposed to have any violent contact with Ms. Scott?
I didn't have no violent contact with her.
And you'd already pled guilty to a battery against Ms. Scott?
That's the one I'm talking about right there. And they took me to court a day early before I was supposed to go to court. And I thought I had to plea out that day. I thought she didn't come to court. And
So you didn't voluntarily plead guilty, you just...
I volunteered to plead guilty to get out of jail. But
That's all the question I have.
All right, Mr. Malloy, in your redirect.
No, Your Honor.
Okay. All right, and that concludes Mr. Smith's testimony. Okay, Mr. Malloy, any other witnesses?
No, Your Honor, defense rests.
Any rebuttal, Mr. Shepherd?
No.
All right, argument.
So Judge, here's my file for the new case, the violation of the family violence order. Here's Mr. Fulton's criminal history that goes with it. It's about an inch thick, 50 cycles on his criminal history, Judge. That's probably about averaging one arrest per year he's been alive. Mr. Fulton's got a history of committing crimes that he's been convicted of or pled to. He's got a history of revocations, including the case that preceded these cases we're here today. He's constantly in trouble. He's constantly failing to do what he's supposed to do. Again, he's failed to report. He's failed to pay his fines. He's failed to get his driver's license. He's got new charges involving Miss Scott. I understand she's hesitant on this, like a lot of our victims are, but something happened that day to the extent that Miss Scott felt she had to call the police. That's not how things normally work in a relationship. My wife and I have disagreements, but the police don't get called. It elevated to that point, and I think we all know what happened that day. Miss Scott thought that was what she had to do to protect herself, because he's had a history of violence with her. Judge, probation's not going to work for Mr. Smith. It's just not. We've tried it. It will not work. He will not comply. I'm sure he's sitting here telling you now that he will. He'll do everything he's supposed to do, just like he always does, and then he doesn't do it, and he's going to get revoked again. Enough's enough. It's time to revoke him. We're asking that you just revoke the balance on both of these cases, because he's not going to be a candidate for probation anymore.
Thank you. Mr. Malloy?
Your Honor, I'm just going to address a couple of points. Since my client admitted to the technical violations of missing the appointments and not paying the fines and fees. Just going to address the issue of the new charge. As you heard from the testimony given by the victim in this case, that the condition was no violent contact. They had a verbal argument. There was no physical or any kind of laying of hands on anyone by either party. So we would constitute that this was not a violation of the no violent contact order, and that particular allegation go away. But the court can, of course, still has the up to technical violations to which they can make the decision.
Okay. Thank you for that. All right. The issue on the table is I have 4 allegations. I have failed to report as directed, which he has admitted to that with an explanation that is still an admission. The failure to pay fines and fees, also admitted to that with an explanation. The denial, well, he admitted during his testimony, denied initially and admitted during his testimony. We also have this question of whether or not he committed this new offense, a violation, and, you know, I too was frankly listening very intently to Ms. Scott, and, you know, it's as much as what I didn't hear as what I heard, which is that, you know, they were having a verbal argument that raised to the level that she called the police. And the arrest that I'm showing wasn't for some other charges. The arrest that we're discussing was for this, and the testimony is that the charges, which we're about to arraign them on more finished here, is violation of family violence order. This is not a criminal jury trial for guilt or innocence decided by beyond reasonable doubt. This is a probation revocation hearing, and the standard is by preponderance of the evidence. So, you know, 50.1%. So I find that as far as the court scheduled appointments, that's met. As far as the fine or community service work, that's been met. You know, as far as the new charges go, I'm actually, I don't have to make a decision on that one, and I'm not going to. What I am going to do is skip down to number 4, which says no violent contact with Charlotte Scott, and I am going to find that there's sufficient amount of evidence for me to find that by preponderance of the evidence, he did have violent contact with her, because she did testify that during a verbal argument, she did call the police. Then police arrested him, and he's in jail. And that was sufficient for probable cause for arrest, but I'm finding that that is also true now by preponderance of the evidence. I'm not going to make a decision on the new charges. I am going to arraign him not guilty though on the new charges, and that's Ms. Jordan to provide you with a reset notice so that if and when he gets out, if it's after that point, he'll have his court date and be ready to go. Now, as far as the decision of this court goes, he's violated the special conditions of bond, special condition of probation. And so I'm going to revoke the balance. I see no reason why not to. I also was pulling back all of Mr. Smith's old cases. And Mr. Smith, you've basically been on probation with me my entire judicial career. And every single case you've had with me that I've pulled says request to close case unsuccessful, JWT. Request to close case unsuccessful, JWT. Incarcerated, balance revoked. Incarcerated, balance revoked. So, I mean, that's the thing is you've trained me. You've trained me through your history that this is it. I don't want your opinion. So that's this issue. I really want you to change your ways. I really want you to not be on probation with me anymore. I really want you to have a solid life, but today is not the day. And so I also am going to note for the record that you are no bonded on the new charges. I think that is appropriate. And I'm going to make certain that for the record that you were, I just realized I said you might get out, but that was mistaken. You're no bonded on the new charges, and there's no scenario where you get out without my permission until the new charges are resolved. So you will remain in custody until your new charges are resolved. All right, that's it. You have 30 days from today if you want to appeal my decision. You have 6 months if you want to use your habeas rights. Y'all can take them back. Oh, actually, he needs to sign the reset. I'm so sorry. I'm so used to saying that. Yeah. Yeah. Right. And the other case, only one of them has special conditions. The second one says 120. The first one's the balance. The second one is 120. Tuck to the side. The second one there wasn't a special condition. I'm just saying you'll see that when you see it.
Okay.
That they're different numbers because of the procedural structure. Right here. Lennox House. What are we doing? We went off record for a minute for me to review the recommendation. I think it is proper and I'm gonna follow it.
Thank you,
You all are
Judge.
considering the recommendation as well?
That's correct, Judge.
Great, okay, well, thank you very much. Ms. Corbett, in just a moment, your attorney will present the filled out orders. He'll sign it, you'll sign it. And then once you've signed it, it'll give you your next report date. The bailiffs will give you copies to take with you, and Mr. Singleton, you may get a copy.
Thank you, Judge.
Do y'all need anything else on the record?
I don't believe so. Well, she had one question that I don't believe I can ask probation.
Okay, I'll let Mr. Singleton ask that.
Great, thank you so
and get that
much.
answer for you. So, Ms. Corbett, if you'll step back out to the gallery, we'll get you that.
You start, can I get you to raise your hand, please? You swear that the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do. Before God.
All right, so can you state your name, please?
It's Tanya Nichelle Willis. It's formerly Tanya Nichelle Davis. Your Honor, I do not want to associate that name.
What name would you like me to call?
Tanya Nichelle Willis.
Willis.
Yes, sir.
Yes, ma'am. Ms. Willis, I will be happy to do that.
All right, and so Ms. Willis, Ms. Leach here in front of you is taking down what you say, so just make sure you speak in the microphone there.
Yes, sir.
You're not soft-spoken. I know we spoke earlier, so I'm not that worried about it, but I just want to make sure we get everything down.
I understand. Thank you.
All right, so Ms. Willis, and you were previously Ms. Davis.
Mhm.
All right, were you married to Mr. Davis?
Yes, sir. I was married to him from 2004 up until March 21st, 2023. Superior Court granted me a divorce.
And is that Mr. Davis standing right here?
Yes, it is.
And you're aware that Mr. Davis pled guilty to a simple assault under the Family Violence Act back in November of 2022?
Yes, he did. I'm aware of that. Yes, sir. I was
And
there.
you were the victim on that?
Yes, sir. I was there.
And you're aware that as a condition of his probation, you have no contact with you?
Yes, I'm aware of that.
And you have reported to my office as well as probation and law enforcement that he's been continuing to have contact with you?
Yes, I have.
So what has he done since November? Because what we're concerned with, like I told you earlier today, is not everything that's happened. I understand there's a lot, but since November, when he was ordered to have no further contact with you, what has he done?
Starting first in November, that's when the contact started. He didn't do it by phone. What he did to me was people that I associate with. He would have a conversation with them. For example, a family member of mine have children by one of his closest friends, so they conversate through FaceTime a lot. And on that FaceTime call, he told two of my family members to tell me that he still loves me. Of course, it got related to me. Of course, they discombobulated me. That's his way of trying to go around the order and to have contact with me. Again, in November.
Has there been, you were telling me earlier about an issue on March the 7th where you have an alarm system in your house?
Yes, sir. I have an alarm system through Xfinity. Over a year, ever since the second CPO was extended in November.
All right, tell us what happened.
I was allowed to, the owner contacted me because I had to move out because I left in December of 2020, December 17th, because he had unleashed so many vicious acts on me. And the things that he was doing, he was just out of control. So I had my family members come remove me and my things. At that point, that's when all of this started. And we ended up back in court. This man has continued to hoover me everywhere and everything I'm associated with. Destruction of property is happening. I have pictures of it. Everything that I'm associated with my family members, every single of Griffin, from Taylor Street to Poplar Street to 11th Street. My family members live there. Everybody's contacting the same thing: property damage, car damage. My car is in Geico right now for vandalism. My sister's car got vandalized Monday. We have police reports for all this. Every time I call the police, they're like from March the 7th all the way until the 12th. I probably have over 12 reports. I was treated so bad by the police. Every time I called, they was acting like I was a nuisance. They treated me like I understand about cameras. I understand that, but I was trying to get evidence from them because I had burglary in my house, fingerprints there, destruction of property inside, outside. The police would not assist me. Half of them wouldn't give me cards, and I had proof. He's tampered with the mailbox. He's stealing mail. He still have his mail coming to 215 address.
Hold that. This is the second time you responded. You respond again while she's testifying, and you and I are going to be crossways. I would never allow her to act that way in such an inappropriate manner while you were testifying. Okay? So I let it pass the first time, but I'm letting you right now, knock it off. You will not disrespect a witness in my court while they are testifying. I understand you don't agree with what she's saying, but you keep your physical opinions to yourself. You may continue.
And yes, sir, and that's his character. So I'm used to that.
of 20 years, same thing with this man from day one.
So I'm looking for a very specific bit of information here, ma'am, which
Yes,
is
sir.
when
So on
did he
the-
have contact with you?
Yeah,
How was it?
Yes, sir. On the 7th, I changed my alarm. I had to go out into my car. Someone told me to go out into the car and change the alarm code with extended. And I realized when I moved back in February 2022 that, 2021, that I didn't register with Infinity. So I thought about it that day on the 7th. So I went to the car, locked myself in. I couldn't even park my car in the yard because it's been vandalized. So I'm parking in front of the laundromat that's on Taylor Street and 11th Street, the Sunshine Laundromat. I'm parking in front of that camera, so the rental car won't get affected. So I leave. It was like 12:35. I register. I changed the code. Register. I leave at 12:35. 12:35. I get a phone call from Xfinity. And I get a text, an alarm, triggered. The lady, she called me and she said, "Movement, your front door's been open." And she said, "The police has been dispatched." So I turn around, I get there, the police make me stay outside. They go in and check. I'm trying to tell them, go to the attic. And they didn't do what I asked. And I know they didn't go to the attic and they didn't do a full search because I changed the lock in the attic and I had the key in my hand. They would not go in the attic. I left again. They said it's clear. So I went in and reset the alarm, Judge. I went along 2 minutes. I get another call from Xfinity. I got it right in this book. They said, "Your alarm has been triggered again. There's motion upstairs in the bedroom. The attic leads to the bedroom." I noticed that I had to keep the lock on that door. It was in a purse inside the closet that leads to the attic. And it was 2 keys. One of the keys were missing, and I noticed that he left a mark. Everything he's instructed in the house, he leaves little marks everywhere. It's a mark out of the door. He let me know he had a key. That's how he was getting in and out. The section of the attic, when I left and the police, I came back. The same cops that I called and told them about the burglary and they wouldn't give me a record, they went right past me and did not stop. I was so appalled. They wouldn't even stop. So I went in the house myself and I went to the attic. I couldn't see him on the door. I said, it's some kind of way Demetrius is getting in this house. I went out to the back where the laundry area is. It's a opening up there. I got the broom, I pushed it, and the sheetrock that was covering it just fell out. I didn't want to go up in there because I was scared. But what I did, I got up in there and I stood on water heater and I took pictures of the whole thing. And it's behind the attic. It's upstairs, but it's covered up, but it's a whole different section. So I took pictures of it and I went down. I had got my uncle to stay there. I asked him to stay there while I go get something to cover that part up because the opening, so I could cover it up so no one can come through. So I went and bought a piece of wood. While I was gone, my uncle was supposed to sit in that same spot. Unfortunately, he didn't. He's 73 and Lord knows. He went and sat on the front porch and shut the door. I came back with the wood, went in that area where I had just taken that part down, the part that had fallen, the sheetrock. It was fabulous, so pouring everywhere in a bag that I use to clean with, and I keep it outside in the laundry room. It poured all over the floor, all over the kitchen floor, all in the trash can, and then put the fabulous soap on the sink, which is why I never use it because it's in my work bag.
I got to narrow this in because again, this is supposed to be a very short.
I got you. I understand.
And I'm looking for if at any point he had contact with you that you can say, Mr. Shepherd, I'm just going to hand this back to you.
So, Ms. Willis, you believe that he was in your attic?
Oh, yes, sir. I know he was in the attic.
But did you see him in your attic?
No, I didn't. I didn't.
All right. So let me, and I know you've called you've provided me with a lot of police reports. This has been an ongoing issue. So on February 24th of this year, it says that you called the police about some damage to your light fixture.
Oh yeah.
And your fence. Right,
yes.
So why do you believe that was Mr. Willis?
Because he steadily stopped me. It's a distress apartment duplex beside me, 217. He's steadily going from 217 to my house 215. That's why he can't be called. But most of the time, he's in that attic. I can feel him. Things are missing in the house, stolen. Things are being moved in the house. The fingerprints all over the house. That's why I couldn't catch him. And he's doing it between the hours of 6 and 8, 3 times a week. when I help my son do a commercial building, and he's doing it between 1 and 6 a.m. when I'm asleep. I had evidence of broken key. Like I get up, my whole key is bent. It's just he wants y'all to think that I'm delusional and I'm crazy. Now what I am, maybe a woman that's had, I'm 53, born and raised into a family of violence on my dad's side. I went through that from all my life, and I end up doing the same thing in my life. So I've endured from 5 to 53 sexual harassment, sexual everything, you name it, violence, manipulation from him, everything in the world. And Lord knows this man worked for the Department of Corrections for 13 years. He knows the ins and outs. I guarantee you, you pull his record right now to find a work record, you will not find one. Because he is a predator. That's what he is. He roams through the night like a rodent, going from everybody that's associated with me doing destruction of property. Right now, since I couldn't get help from the city police, I went to Detective Captain Homer Daniels on yesterday. The same evidence I had here, he has that evidence. And what they informed me what they want to do, they're going to start an investigation. And I was instructed to go do aggravated stalking thing, and I'm going to do that because he's doing that, Your Honor. And he knows what he's doing. This man don't work. This man is steadily actively stalking me. I can feel him. I can go to the grocery store. I come out the grocery store. Buggies, 2 buggies. It's the thing. He wants y'all to think I'm crazy. But I'm not crazy. I'm not delusional. I'm not none of that. He's malicious, cunning, conniving, and manipulative. And he's gonna do everything he can. He still have those weapons. And like I told those police, he's gonna do everything he can to continue to stop me. Because he blamed me for everything happening in his life instead of himself.
All right, Ms. Willis, let me ask you. I'm trying to narrow this down, like the judge said a few minutes ago. There's another police report here from February 27th, where you called about some damage to your vehicle. All right, so why do you believe that was Mr. Davis?
Ever since when I found the first incident, we started damaging that car when I left in 2020, he's been damaging that car. And he just continued to come over there and vandalize that car. I check it every morning. I got pictures where every morning and every day there's a new place where it's being vandalized. Geico has the car right now.
All right, so I got another. So March 1st, you made a call that day about front bumper damage and an issue with your mailbox. Why do you believe that was me?
Because the front bumper damage, where it's just like somebody just been pulling on it. I can stick my whole hand down in that light of that car. And it's just, you can tell somebody is just vandalizing the car all the way around. I was in the front yard with Officer Powell. We were in the front yard for approximately 30 minutes. I came back. I didn't lock the car. I came back. It was a new dent in the place that I already did. Then he had cut this thing that fast. Because he's in the vicinity. I had pictures that I have for the court where I was showing property damage on 217, on my damage. There could be an actual interest for him to get through. They said they were going to investigate, and his cameras, the mailbox was just beat all up. And I called and I made a report. I was post office told me they're going to make a report with the police because they couldn't do anything. The next day when I came back out the next morning, because I took a picture, the mailbox was just straight. It just standing right back up. In the middle of the night, somebody came through and just fixed it. Everything I report the next day, it's probably been tampered with again or tried to be fixed like I'm delusional or like I'm telling lies. He's just toning with me. And that's why he's just toning me. He knows it. And he knows I can't get proof. But now, after the 7th, I got cameras on the 9th through advanced direct cameras up here. And I also have to get inside cameras with Comcast. And this is, and I had to spend money to do that. And it's funny that since I got the cameras, all the things that I'm reporting, all of a sudden it ceased as around the 11th. The activity just ceased.
Okay, thank you, Ms. Willis.
All right, Mr. Shepard. So, Ms. Willis, you've called the police these numerous times. You said there's an ongoing investigation with Captain Daniels. Is that right now?
He started yesterday. He told me that I also want to call me tomorrow at 4. Yesterday at 4, but they didn't call, so I'm going to go follow up on that today. And I was also recommended by the clerk when I went to get the documents of the court that I had in my purse in this pink book that was stolen on the 9th, but I couldn't get the police to do anything about it.
So Ms. Willis, I got one more. That on March the 6th, you called the police that he had been coming into your house and stealing clothing and all that.
Yeah.
Why do you believe that was him?
Because all of a sudden, my underwear started missing, bras, panties, and I talked to her about my son, and he said, "Mom," he said, "that's strange." He said, "Because my boxers and my socks are missing too." That's because when I leave or take my sister to work, I come back. The same malicious acts he used to do to me when he was there, I come back. We'll take my sister and take a shower. The shower curtain is tore down. He'll defecate in the toilet and let the lid down and leave it in there. And the toilet was just full of black soot for months and months and months. And we could not figure out where all this black soot was coming from on the walls and the toilet. That's because it was coming from the attic. He was taking a bath. My toothbrush will be wet when it shouldn't be wet. My towels are wet when they shouldn't be wet. You know.
Yes, ma'am.
All right, so you have security systems now?
Yes, I do as of the 9th.
Okay.
I
And so since then, this behavior stopped?
Nothing. Everything ceased. Like the police, they kept telling me, "You gotta get cameras, get cameras, get cameras."
And so do you have you got any of the footage from those cameras yet?
Not as they came out on yesterday, and I got some of it, but the price that they were charging me to pull that footage, I couldn't afford it, so I paid $55, and I had to tell them that I couldn't afford the rest of it.
Right, and so,
So he showed me how they're gonna turn back and they're gonna show me, because I just got it, so I'm not familiar with it. Yeah, I'm gonna be honest. So they gotta show me how to navigate it. He's gonna come back. He's gonna give him a call.
Okay.
He's gonna come back and show me how to navigate it. But I just had so much going on trying to build my own case because I can't get help. Because I don't want this man to kill me. He been in over me and my child while we were asleep. That is so frightening to me, and I know he would do it because he's a predator and he's evil. Jesus.
Ms. Willis, what other incidents, I've gone through several with you, and I know you've referenced several others. What else do you want the judge to know about him contacting you since he went on probation in November?
And the same malicious act, putting everything that he destroyed before he left that I had in 2020, I threw all the way. I buy new clothes, and Lord knows, my clothes continuing to get the same holes. My son got the same holes in his clothes. It's just ridiculous how this man just sabotage stuff. It's crazy. And I threw away all this stuff, all of a sudden, the same malicious acts are continuing from February the 20th all the way to March 2023. And it ceased as I got the cameras. He say he worked, but I guarantee you pull a record, you won't see nothing.
Are the cameras visible around your house?
Yes, they are.
Are they
I got
obvious?
a total of 12 cameras now. I got 4 on the outside and the rest of them all on the inside. You can put them in the attic.
All right, so if I walk up on your front porch, do I see a camera pretty easily?
You'll see it now.
So it's on.
As of the 9th of March.
All right, so is there anything else you want to tell the judge about this?
Like I said, Judge, I'm just a woman who may have been battered in family violence. I may have PTSD, but I'm not delusional. I know this man is doing this, and he knows I have what I did when I met him. I don't know if you know the word pillow talk, but I told this man my entire life because I trusted him. And what he did in turn, he turned around and used it against me to abuse me all the 20 years that I was with him. And he's continued to do it because I left him. He's angry because he don't have that control. He don't have the financial control for me no more. He don't have the financial abuse for me no more. I was the breadwinner. When I had a wreck in 2018, couldn't work anymore due to an injury, lost my job. That's when the control he showed me what he really was there for.
Thank you, Ms. Wills.
Judge, I don't have any more questions from Ms. Willis right now. I think she's told her.
All right, so here's where I'm at on this. So I've heard the evidence, I've listened very closely to what Ms. Willis has testified. And Ms. Willis, I do believe you've got some really profoundly difficult things going on. I'm thrilled that you have cameras up now. That reassures me greatly. And I'm thrilled to hear that GPD has got open investigations that they're going to look into and see if they can help find some closure that is concrete. This court must make decisions off of concrete.
I understand.
Unfortunately, for you, I've not heard enough very concrete stuff from me to make the for me to find that there is probable cause to arrest him, which also means that at a final hearing, you would be unable to find by preponderance of the evidence. So here's my decision. I'm actually just gonna convert this back into a revocation hearing, and I'm going to find that there was insufficient evidence. But I've written on here that there is permission to rehear and refile from the state upon conclusion of the Griffin Police Department investigation or other concrete proof. And so, Ms. Willis, if you will just communicate with the Griffin Police Department, Solicitor's Office, and Probation, and once a decision has been made on that investigation, if it's concrete, regarding Mr. Davis, then they can have permission to refile, and I'll be happy to rehear it at that time. So this is I want you to think of this as a no for now. And it might be a no forever, but it's a no for now. And we'll make that next decision as we go. So, all right, well, I've converted it back into a probation hearing. Your hearing is finished and you're concluded. You need to sign this, Mr. Davis, acknowledging that I have found no violation. And report whenever your next scheduled report date is. Ms. Wilson, if you'll sit tight, we're gonna have him head on out, and then Deputy Carr, Deputy Piper will walk you out to your car.
Thank you.
Make certain you get out there safe. Thank you, Ms. Davis. I would suggest you be very silent, sign it, get your copy, and get out of here.
For the court's information, my office indicates that there's no record of him having applied.
Correct, no application. All right, let's take a 5-minute break and then we'll step into the last year's I don't suggest.
Can I?
You're welcome to talk to him, but your matter's closed.
Oh, it's closed?
Yeah, you're done. So, go and send them on.
Ms. Willis, wait on him to, let him get the business before you. You can walk around.
That's fine. I need to step off the rest real quick. What's the deal with Smith?
Ready? We're ready, Judge.
All right, everybody, let's come back to order. We're gonna do the motion to revoke bond on Sarah Smith. Ms. Smith is present. Mr. Park will be representing the state. Mr. Malloy is here representing Ms. Smith. Mr. Parker, is the state ready?
It is, Judge.
Mr. Malloy, y'all ready?
Yes, Your
All right. I don't think so. Let me see. I think I'll just have him. All right, Mr. Parker, the floor is yours.
Okay. Your Honor, we only have one witness in this case. The witness is the victim in the underlying case, Mr. David Jones, and we would call him to the stand at this time.
All right, let me just put him over there so I can leave Ms. Matthews where she's at.
Mr. Jones, if you'll come up and have a seat right here, sir.
Mr. Malloy, any housekeeping before we jump in?
If that's the only witness, Judge, I
Yeah.
can't think of anything.
Okay, that's what I was looking for as well.
If you'll raise your right hand, Mr. Jones. Do you swear or affirm that the testimony you give this court today will be the truth, the whole truth, and nothing but the truth, so help you God? Okay, you understand that you're under the penalty of perjury and you have to tell the truth here today or else you could be in serious trouble with the court. All right, please have a seat. If you'll say your name for the record.
David Jones.
Mr. Jones, are you the same David Jones that is listed as a victim in the case of State of Georgia versus Sarah Elizabeth Smith?
I am.
And was that an incident in the underlying case that arose out of a physical altercation between you and Ms. Smith?
Yes.
Was she arrested in that case for a family violence related charge?
Yes.
Was she granted bond in that case?
Yes.
And as a condition of her bond, was she directed and ordered by the court to have no contact with you?
I wasn't fully aware of what the bond conditions were detailed as. I was under the impression that it was no violent contact, but there was a bond condition, yes.
Have you now been
Can
made
you up into that mic so I can hear you a little bit better? Just pull the mic towards you.
Have you now been made aware that her bond in fact required no contact with you whatsoever?
Yes.
Has she in fact had contact with you after making that bond?
Yes.
Now, this case arose when I filed a motion to revoke or modify Ms. Smith's bond, the bond that we were discussing. And that happened because you visited my office with some concerns about her recent behavior. Is that correct?
Yes.
And you filed a written statement with my office. I'm going to ask you some questions about that. You allege that Ms. Smith has had contact with you.
You know, I'm object to this being leading and let him tell the story instead of Mr. Parker putting the words there.
I can draw it out by.
No, that's okay.
Question,
We're-
Judge.
All right, so although Mr. Malloy's statement is correct, it's not a jury trial. We are a little tight on time, so I am going to allow leading and then I'll allow you. But the objection is valid, but I'm going to move this along. So you may continue leading.
I was trying to save us some time.
And I'm okay with that. Again, Mr. Malloy can clear across. He's excellent at that.
So, let's see. This is a statement, Mr. Moore.
Oh, and either way, she's got an arraignment scheduled for May 8th. So no matter what we do today, she's here and you're here. I'd like to arraign her.
Yes, sir.
Today and go ahead and get her case moved forward, no matter what happens with the hearing.
Sure. All right, Mr. Jones, I'm approaching you with a piece of paper here. Can you look at that paper and tell me if you recognize it?
Yes, I do.
Okay, what is that?
That is my statement about her relapsing on drugs, not following the no contact bond.
Okay, I'm sorry, let me stop you. Just, we're generally identifying it for the record. Is that the statement you came to my office and made about your concerns regarding Ms. Smith?
Yes.
Okay, number one there, can you tell me what your first concern was about her behavior?
That she had relapsed.
By relapse, can you tell us what your statement was there that you wrote?
Meth, pills, and weed.
In fact, your statement says she has been taking drugs, meth, pills, and weed. Is that
Yes.
correct?
Yes.
Okay. Can you tell me on number two there that you wrote out, what you said was a concern in this case?
You want me to read it word for word, or just?
You can, sure.
I mean,
You can.
it just explains how we kind of violated, or how she violated the no contact order.
Okay, you asked me if I wanted you to read it, and I said
Okay.
yes, please read it.
Has not been following the no contact bond for a while now. I did allow this for some time since she was clean from drugs during this period. I allowed her to come back given I did not want my son to be homeless or put in any harm. DFACS was involved, and they are involved again. They helped us with co-parenting and following the no contact order for a while. It was going okay for a while until Sarah relapsed on drugs again. My son is not in a safe situation now, and I am very concerned for his well-being.
Okay, thank you very much. So you said in there that Ms. Smith has actually come back to reside with you after she made bond in this case, which required her to have no contact with you. Is that correct?
That is,
Did she do so with your permission at that time?
yes.
Okay, and why did you do that if you knew her bond did not allow contact with you?
At the time, I wasn't aware of a no contact as it stated before. I was under the impression it was a no violent contact. The reason being I allowed her to come back was because for our son's safety. We have a 3-year-old son, and I didn't want him to be out on the streets.
Okay.
She was being kicked out of where she was staying at the time.
Show that to you and ask the question.
There was messages left, or just missed calls.
Those I showed you as well.
Okay, yeah, we might. I don't know if I have it, but I'm not going to argue with that, my bond. that they didn't? Or no, these are what years?
Yeah, that's gonna be a question.
Okay,
I mean, that's-
okay, yeah.
Mr. Jones, you testified just previously that you thought that the bond had no violent contact with you as a requirement, but it in fact had no contact at all.
Yes.
Can you tell me on this paper that I'm showing you, which is a copy of the special condition of bonds for Ms. Smith, you see the line that says defendant?
Yeah.
Is that your signature?
No.
Do you recognize that signature?
It's Sarah's.
That's Sarah Smith's signature because she's the defendant?
Yes.
So you didn't know that it said no contact, but she did because she signed that paper, is that right?
Yes.
Showing you second set of documents. If you can tell me what those are, that'll be marked as State's Exhibit 2.
It's, phone calls from Sarah and, yeah, list of phone calls.
How did my office come into possession of that list of phone calls?
I gave them to you,
Where did you get those from?
my phone.
How did they get into paper form?
I screenshot them and printed them off.
And what did they show?
Missed phone calls from Sarah.
From Ms. Smith to you?
Yes.
That would be a form of contact.
Yes.
Showing you what would be marked as State's Exhibit 3. Can you tell me what that is?
Text messages from Sarah.
Okay. How did those come into my possession?
I took a screenshot of them, printed them off.
Have they been altered or tampered in any way since you gave them to me?
No.
Do they accurately represent the screen or the messages as they appeared in your phone?
Yes.
One question to clean this one up, going back to what would be State's Exhibit 2, that was the phone records. They have a date there, February 26, and various dates throughout. What
Yes.
year?
This year, 2023.
2020. That would be State's Exhibits 2 and 3. That would be in addition to your written statement, which would be State's Exhibit 1. And Judge, I would tender all of those to the court into evidence at this time.
Objection?
Well, Your Honor, I do have a concern about the year when these alleged phone calls were made. We do have dates, we have a month and day, but we don't have a year, so.
Okay. I'll let you clear that up on cross, but I understand your concern. Any other objections to the exhibits being placed into the record?
No, Your Honor.
All right, then they're tendered and admitted. I'm gonna say without objection, but with permission to clarify on cross. Okay. Is that fair, Mr. Moore?
Yes, Your Honor, that's the court's ruling.
Okay. Okay, well then I'm gonna clarify and say over defense objection regarding verification of the dates.
Mr. Jones, I'm going to hand back to you what we've referred to and what's now been admitted into evidence at State's Exhibit 3. That's the text messages. Can you tell me what this series of text messages is about and the types of things? In fact, you can read those to me.
Some of that.
I know you don't want to read it, but it's important that it be in the record for the court. We are here to address your concerns, so I'll ask you to read those in the records. If you don't want to say the really bad words, you can abbreviate those, okay? Can you tell me what led to the series of text messages?
Mostly just arguing, basically.
What were y'all arguing about?
Honestly, sometimes I don't even remember. You know, ever since I found out she relapsed, it's kind of always been about like that.
Okay. When you say
Just wanting her to be a better parent for our son.
when you say she relapsed, is that what led you to come to my office?
Yes.
Is that your main concern in this case?
Yes.
And that being substance abuse issues?
Yes.
Did that lead to the series of text messages that you have in front of you?
Yes.
Okay. And I'll tell you what, I'll spare you. The judge can look at those. They're in evidence. But can you summarize what that series of text messages is about?
It's basically name calling, talking about defects.
The name calling, were you calling Miss Smith names in these text messages?
Not in those, no.
Was she calling you names in these text messages?
Yes.
Provide those to the court recorder. They have been marked State's Exhibits 1, 2, and 3 in the top right corner.
I'll take it.
Okay. What do you want to see happen in this case? Are you asking that we put Ms. Smith in jail because of your concerns?
I'm not.
What would you like to see happen if defense will allow you to?
Personally, I just want to see her get clean to be a better parent for our son. Because he does love his mother. He does need her. But she needs to be in a better place. And whatever environment she's in, he doesn't need to be around it. And she needs to get sober.
What about the contact aspect? Now, what we deal in is whether she can have contact with you or not. And in fact, that's what we're here about today. So what would you have the court do about the contact? Do you want her to have no contact with you? Do you want her to have contact with you under the conditions you've just stated? Or you tell us, what about the contact?
Only in regards to our son. I think that should be the only form of contact that we have.
So it'd be accurate for me to summarize your feelings as you would like to have contact with her for purposes of co-parenting
Yes.
only.
Only co-parent.
Okay. I think it's all the questions I have for the judge.
All right, cross.
This all stems from an incident that occurred in May of 2021, correct?
Yes.
And there were actually a couple of things that went on in May of 2021. That sound right?
Yes.
And included in that, there was also I guess a defects matter that came out of this that involved both of you, not just Ms. Smith, correct?
Yes.
Okay. So, and in that, defects looked at both of you and whether or not either one of you would be considered fit to have custody of your child. Is that correct?
Because
Just answer the question yes or no first, and then you can explain it. So it wasn't just her that defects looked into, it was you also. Is that not correct?
Yes.
Okay. And from that iteration with defects and with the custody of the child, who's going to have it and might not have it, would you?
State just objects as to relevance. This is a bond hearing. Did she have contact with him or did she not? That's what we're here on.
I get it. I'm gonna allow it because I'm kind of curious about, if I don't revoke it, I'm kind of curious about framing up some middle ground. So I'm gonna let you move a little farther into that, Mr. Malloy,
Thank
because
you.
I think I see where you're going.
Thank you. The results of what happened with defects, would you say you were under the impression that having contact with her was allowed according to what defects explained to you as far as doing the co-parenting?
Yeah.
Now back to the statement that you hand wrote that Mr. Parker. And when did you write the statement? There's no date on it, so I just find that kind of interesting.
2 weeks ago.
All right. And you made comments in the statement about her relapsing. Do you have any proof of her relapsing and being on drugs? Have you seen her using drugs?
I've got pictures and text messages
Pictures and text messages of her using drugs?
admitting, yes.
But you didn't provide those to Mr. Park.
I have them on me right now. They told me to bring them in with me. I didn't have them printed off when I came up here to file a statement.
Judge, I'll just, in the form of objection, put on the record, we did not tender those because, again, they are not relevant to whether she had contact with him, and we were seeking to minimize any embarrassment to Ms. Smith. Again, we were just trying to focus on, did she violate the bond?
Your Honor, the state asked Mr. Scott to actually read what was in his statement, and that's what's in the statement, so that's why I'm addressing it, Your Honor.
Mr.
We'll tender.
I was about to say, you can testify about them, and then I'm gonna have you provide them after the hearing to the state, to be part of the state's case, so. So you can answer Mr. Malloy's questions and then provide them to Mr. Parker when we're done.
Okay, and also in this statement, you said you allowed her to be there, so even after you knew that she had this condition of bond, you still let her come stay with you, is that correct? So you actually, yes or no?
Yes.
Okay, so you actually facilitated or promoted her being in violation of her bond condition?
Bond condition I wasn't fully aware of. I've never actually seen her bond condition until 2 weeks ago when I picked it up from the clerk's office. So I didn't know the details about it. Like I said, I was under the impression that it was a no violent contact.
Do not express your opinions about his testimony in this court. You were present earlier with Mr. Davis's, so which means you should have known better. So you keep your physical opinions of what you think about his testimony to yourself. Am I very clear? Don't do it again. You may continue, Mr. Malloy.
Thank you, Your Honor. Next question I have is dealing with one of the actual text messages that was presented to you. I see on this it has a name of Sarah Smith at the top, and why does it have that name on there?
That's her name.
I don't mean, but how does it, is this how it printed out on the phone? Well, how did that name get there?
That's what she's in my phone as.
Okay, so this message came from her phone, right?
To my phone, yes.
Okay, but you don't know for sure if she was the one who sent you this message. This could have been sent from someone using her phone. Is that possible?
No. She has a phone lock on her phone.
So you're saying,
That thing doesn't get out of her sight.
but you don't know that for sure.
Okay, I don't.
Okay, so it's possible that someone else could have had her phone and typed this message to you from her phone. Is that?
But the way the
possible?
text messages are, and of course, and you'll see in one of those, she sends pictures of me and my son. I mean, who else is gonna send that? And then saying your son misses you.
So you're going to stay here that the only way that the only person could send you a message from that phone must be her. Is that what that's your belief right now?
Yes.
Okay, but it's possible it could be somebody else.
I mean, it could be,
Okay.
but it's not.
Your Honor, may I have a minute?
Yes. Thank you. Mr. Lloyd, you may continue.
Okay, so is it true that it's actually Ms. Smith who has primary physical custody of your child?
Correct.
Is it also true that you have not even legitimated that child
I
yet?
filed for legitimation 2 years ago, which she refuses to. It's still here. She even told me
Piper,
she wasn't.
take her into custody.
Oh, no,
I've already told you
I'm
to
so
stop.
so sorry.
Now they're getting louder, so you just put handcuffs on her and leave her at that seat. Put handcuffs on her and leave her in that seat. I need her to understand, you can cuff her in the front, because she may have to sign something. But she needs to be in handcuffs so she understands that, like, this is not some sporting arena where you get to voice your opinion as to what's going on. Now sit still, remain silent, and let this witness finish his testimony. You may continue, Mr. Moore.
Your Honor, I was actually almost done. I was trying to
I
just
know,
make sure
I
you
know.
got the information on the record.
I was aware that you were almost done, and you were doing a great job, Mr. Malloy. It's your client who's keeping this thing from moving forward.
Because the court wanted to be clear on who actually had the primary physical custody.
Yes.
So we have established that is my client, Ms. Smith. And that the witness here is actually not even, as today's date, legitimated as the legal father of the child, so.
All right, so if my order up here said something to the effect, I know we're going off script, but, okay, so if my order up here said something like, no contact with David Jones except by text for the purpose of child care, Mr. Parker, would that, because text could obviously be reviewed, we've already proven that here in the courtroom.
Yes, sir. Just one moment, Judge. Yes, sir, we'll be fine with that, sir. How was he gonna have the kid? Well, and Judge, we understand, and I just want Mr. Jones to understand that this is not a custody court. You're
No.
not saying he has custody or any right to it, but that any contact between Ms. Smith and Mr. Jones shall be limited to text messaging only regarding any potential visitation of the child. So we're not saying he has that right, but if DFACS or any other court were to say he did, the contact would be limited to text message regarding that subject only. Okay. Thank you, Judge. With that, we're fine today, Judge. Thank you, sir.
All right. Okay, Mr. Malloy, anything else?
I just want to say, Judge, I think what we kind of come to the conclusion is that because of the involvement of DFACS in the case, and they were given certain instructions from DFACS on how things will work. Now, I did ask my client about, the bond condition, and I'm not going to say it's valid, Judge, but she doesn't recall it, okay? But still, based upon the fact that they were given different instructions from DFACS, and they both seem to admit that they didn't understand how this came out to be, because DFACS told them it was okay for them to be together, and the co-parent, that's the parameters on which they were operating. Until now, these new allegations have come out.
Got it. All right, that's it. Okay, well, let me tell y'all what I kind of have, and then let y'all respond to that to give me some directions. Is that acceptable, Mr. Parker?
Yes, sir.
Okay, I know that's out of order, but that'll give y'all an idea of where I'm at and streamline your thoughts. So what I did was I grabbed the Fisher order, which is kind of our go-to order, and I simply said that basically that there is enough for me to revoke the bond, but I'm not. Instead, what I'm doing is that she's going to report to JAG within 72 hours of the date of this order. She'll be supervised by JAG probation pending trial. She'll report in person at least weekly or twice weekly, and shall pay a monthly supervision fee of $60 per month. She shall not consume alcohol, illegal drugs, or hemp products. She shall be tested as often as necessary at JAG probation for illegal drugs, hemp products, and alcohol. She'll have a substance abuse evaluation completed within 60 days from today. and provide, proof to JAG. She'll have no contact with David Jones except by text only, and for child care communications. I understand he's not legitimated, but obviously he is a part of this world, and that will allow that. Shall stay away from his residence and employment, shall possess no firearms, ammunition, or have access to those. I have in here to attend a family violence intervention program. I'm on the fence on that one. And then lastly, you may follow probation, you may follow any order from Superior or Juvenile Court that contradicts with this order. Does that make sense? All right. Okay, go ahead.
I was just gonna ask, as far as because of the list of things the court's already impaired, being almost like a single mom, taking care of the kids. I don't wanna have her have too much on her.
Okay.
So that's what, if you could just pause on the program for right now, because.
That's fine. I've taken it out.
Thank you.
Mr. Parker, I'd love to hear your thoughts.
I think it would be a good thing for her, but I do understand the current conditions they're in, Judge, and I think with the other safeguards you put in place, I think we're okay with that.
Okay, and she does have to have an evaluation. And so I know what I'll do. We'll split the difference. It'll be a substance abuse evaluation and a family violence evaluation. And that way, if it says she's good, then we're clear. And if it recommends something, then I'll make that part of the bond. That'll balance it. Okay, well, that's the order of the court then. If everybody's good, go ahead.
If there is a Superior Court order or a juvenile court order, can she be responsible to provide that to us?
Yes.
So I'm not responsible for finding said order.
Mhm. I'm gonna put defendant is responsible for providing certified copy prior to compliance. Got it. Anything else? All right, I'm printing it. Okay, does anybody else need anything else on this case before I sign this, give you all copies? Okay.
No, sir.
I see why we had this hearing, by the way. This was a tricky set of circumstances. Mr. Parker, I'm going to pass your exhibits back to you to keep in your possession.
Thank you, sir.
I'm printing the order now. If we'll sign it, you all may remove her handcuffs.
Yeah. That should be, that should be your top priority for today.
Okay, I'm gonna just sell a report tomorrow. Perfect. All right, Ms. Smith, you are to report tomorrow at probation. Mr. Malloy can tell you where they are. I've signed the order. If you all will please make 3 copies. Ms. Erica's had to step out, so we're not gonna be able to stamp it in, but everybody has copies and they'll get stamped in later. Mr. Jones, that completes your testimony. If you have any questions, you may follow up with the victim advocate at the solicitor's office, and of course, Mr. Shepard in his office. All right, do you have any questions for me? All right, thank you, Mr. Mr. Hutchinson,
Yeah, hang around, I'll get you a copy of that. Yes. James, will you make an extra copy of that one?
Do you have it?
Yes, sir. Yeah, we got it already.
Okay.
All right, everybody, let's come back to order. Are you Robert Allen Vanderberg?
Yes, sir.
All right, state, raise your right hand for me. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, take your hand down. Mr. Shepherd, do you have the final disposition?
I wrote it up, Mr. Judge.
Mr.
Can I give it to you? Pat?
Do you have it? I have the right sheet, I do not
Yeah,
have
it's right there.
Yes. This one,
I haven't hung up that with you.
hopefully he'll never have to meet with him. Yeah. So if you wanna, he's gotta sign it, so.
Yeah. Robert, you remember us going over this specifics? This one, good one. Don't exactly what I would. You understand that? So, we didn't see this.
I had to get it done.
Judge, I didn't have it in written form yesterday, but I did go over the, all the different things, and so he's gonna be able to sign it right now.
All right, that's good. Like I said, if you need more time, I can do it here. All right. All right, let's just start fresh. Mr. Vanderver, raise your right hand. You solemnly swear affirm testimony about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Take your hand down and state your full name for me.
Robert Allen Vandiver.
Mr. Vanderver, you're here on 22 SR 0345. I'm gonna ask the court reporter to make a transcript of this plea, and here's how this is gonna work. This looks like a normal plea, except the fact that when I get to sentencing, I'm gonna stop. You're gonna then go successfully complete the accountability court. And I'm gonna let you withdraw this plea, and then your case will be dismissed pursuant to the negotiations. You understand how that works?
Yes, sir.
If you do not successfully complete the accountability court, I will sentence you according to the terms that are on this document exactly as they are. Do you understand that?
Yes, sir.
Is that acceptable to you?
Yes, sir.
Is that acceptable, Mr. Hudson?
Yes, Your Honor.
All right, Mr. Vandenberg, your attorney you were here yesterday, or is it 2 days ago?
Yesterday.
Yesterday, and you heard the rights I read out to the courtroom?
Yes, sir.
And did you see the PowerPoint I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Any questions I can answer for you about those rights?
No, sir.
I have this attorney and defendant plea rights waiver that I'm holding up. Do you recognize this document as the written version of those rights?
Yes, sir.
Are those your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
And is this your signature?
Yes, sir.
Did you sign and initial this document after having all the time you needed to review it
Yes, sir.
and to ask your attorney any questions you have about it?
Yes, sir.
And because you understood everything that's on it?
Yes, sir.
Are there any questions I can answer for you about anything on this document?
No, sir.
Have you had a chance to speak with your attorney about all aspects of your case?
Yes, sir.
Are you satisfied with the job Mr. Hutchinson's done on your behalf?
Yes, sir.
You understand that you have the right to a jury trial,
Yes, sir.
and that by entering this plea, there will be no trial, this case will be closed. Is that what you want to do?
Yes, sir.
Do you have any other questions for me about this attorney and defendant plea rights waiver or anything else before I pivot to your attorney with my next set of questions?
No, sir.
Mr. Hutchinson, do you stipulate on 22 SR 0345 that there is a sufficient factual basis for me to accept this DUI plea?
Yes, Your Honor.
Mr. Vandiver, do you wish to enter a guilty plea to that DUI charge?
Yes, sir.
All right. I'm going to find that with Mr. Hutchinson's stipulation as to the factual basis combined with Mr. Vandiver's request to enter a guilty plea to the DUI charge, that there's enough for me to take the plea. I'm going to find that he is knowingly, voluntarily, and intelligently, but waiving his rights and entering the plea. I reviewed the recommendation that Mr. Hutchinson has negotiated on behalf of Mr. Vandiver, and if the time ever comes for me to sentence, I will sentence exactly according to the terms that are on this piece of paper. Now, that is as far as I go today. What happens next is, Mr. Hutchinson, pursuant to the entry into the accountability court process, actually, I'm just going to say it overall. Do you waive overall the right to withdraw this plea prior to sentencing? If you want me to word that differently, I'm happy to.
Yeah, please do, because the way that you explained it to us initially is that we, upon successfully completing the accountability court program, we would withdraw our plea at that point in time, and the case would be not crossed. And that's not exactly what I just heard.
No, and as soon as I said it, I knew I was wrong. I just
Okay.
couldn't figure out exactly how I was wrong. And that'll be in the transcript too, so that's
Yes.
fine. But the answer is no. Do you waive your right to withdraw this plea subject to your successful completion of the accountability court program? How about that?
Yes, sir.
All right. Mr. Vandiver, same question. Do you waive your right to withdraw this plea subject to your successful completion of the accountability court program?
Yes, sir.
Okay. Then I find you're stuck with me. You're either going to successfully complete it, I'll allow you to withdraw it, and and then this case will be dismissed pursuant to plea negotiations. Or you will not successfully complete the accountability court program, and I will sentence you exactly according to these terms as we go. Mr. Shepherd, obviously it's a new system we're all rolling out. Anything I missed that you can see?
That's the judge, I think that covers it.
All right, and Mr. Hudson, thank you for your patience as we roll this out. Here's what happens next. I'm going to file the attorney and defendant plea rights waiver with the clerk. It's all signed and ready to go. This will also be signed as a, the final disposition has both signatures on it, but not mine. It will be attached to the reset notice that I'm gonna have you sign here in just a minute, giving you 60 days from today, moved to May, to get him into the program, which you're already at full speed. So you'll never see that next court date, but I always have a next court date.
Okay.
And this will be attached to that reset notice.
Yes, sir.
Um,
And that
Any
will just travel with this case until successful completion
Yes.
of the accountability or
So
failing
this
out.
will be attached to both the reset notice, and then Leslie will attach it to the contract that he signs, that goes with the accountability court contract.
Okay.
And so that way it's all there. Kathy will also create a transcript of this plea, including the part where I said the crazy things, and that will go with the clerk. That way, if there's ever a question, a year from now, what happened, that will also be there for us.
Yes, sir. Thank you, Judge.
All right, then I'm gonna let, give me just a minute, I'll get your reset notice. I just realized Eric had to step out.
Yes, sir.
And then we'll get you out of here.
Yes, sir.
If you look on her desk, I think that tray she has some preset, May trials. Okay, you good?
That's all I've got,
You
Judge.
good?
Just for Ms. Smith, did we get the sheets to report tomorrow?
Yes.
By what?
9 to noon or 1 to 6? Well, let's do 1 to 5.
Yeah, that gives you time. 1 to 5. 9 to noon or 1 to 5. I didn't show you. All right, let's run through this last bit.
Between 1 and 5 tomorrow.
9 to noon or 1 to 5. Right?
All right.
Because she has to leave at 5. Yeah. All right. She was supposed to have rain or not. She was supposed to. You know what? It's fine. I got it. Vanderbilt? Yeah. He's just reset to May trials. So that will, if there's still May counter call,
Yes.
May trial.
Okay.
Yeah, maybe he's down there. All right, ladies and gentlemen, for those of you who are left, y'all's generally do not take long. Here's how this is gonna work. I'm gonna call each of you up. We're going to swear you and Ms. Matthews in. I'm gonna ask you if you understand what you're doing here today. And then I will have Ms. Matthews do 2 things. I will have her both put the violation allegations on the record, as well as the recommendation as to what the court's response should be. I will then ask you if you admit to the violations, and then I'll ask you if that recommendation is acceptable. If it is acceptable, I've already reviewed it, I will very likely accept the recommendation. If you do not like the recommendation, I'm happy to come up with my own solution to the question. All right, so let's start with Bradley Fletcher. Come on up. All right, both of you all raise your right hands. You solemnly swear or affirm the testimony about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, take your hand down. Say your full name for me.
Bradley Stevens Fletcher.
Ms. Fletcher, you can grab that boom mic, pull it down for you. Mr. Fletcher, you understand you're here on 21 TK 2397 because your probation officers filed paperwork with me alleging that you're out of compliance with your probation.
Yes, sir.
You have the right to have an attorney and you're here representing yourself, is that correct?
Yes, sir.
Is that what you want to do?
Yes, sir.
All right, Ms. Matthews, floor is yours.
On 21 TK 2397, the defendant is alleged to have violated the terms and conditions of probation in the following. The defendants failed to report to probation as ordered, having missed 4 of 6 scheduled appointments. The defendants failed to pay the fines and fees as ordered or utilize community service work in lieu of the court fine being in arrears, $113. The recommendation on this case is for him to report as directed, payments of $69 bi-weekly, 0 tolerance for 90 days. His next report date would be tomorrow, March 17th, between the hours of 9 and noon or 1 to 6.
All right, Mr. Fletcher, Two questions. Number one, do you admit to the violations?
Yes, sir.
And is that recommendation acceptable to you?
Yes, sir.
All right, I think so too. I think that's an appropriate resolution on your case. I think it nudges you back on track, and I'm happy to follow it. If you will stand over by the hand sanitizer dispenser there, the bailiffs will bring you a copy of your order in just a minute. I'm sorry, they'll bring you your order in just a minute. You'll sign it. They'll give you a copy before you leave. Okay? Gaddis? All right, please raise your right hand. Both of you do solemnly swear or affirm testimony about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right. State your name, please.
Faith Marie Geddes.
Ms. Gaddis, you're on 21 SR 1457 because your probation officer has filed paperwork with us alleging that you're out of compliance with your probation. You understand what you're doing here today?
Yes.
You ready? You have the right to have an attorney represent you, and you're here representing yourself. Is that acceptable to you?
Yes.
You ready to go forward?
Yes, sir.
All right, Ms. Matthews, floor is yours.
Judge, on 21 SR 1457, the defendant is alleged to have violated the terms and conditions of probation in the following. The defendant failed to obey the criminal laws of any governmental unit as ordered by the new citation of no insurance being committed on or about January 26, 2023 in or around Spalding County, Georgia. The recommendation on this case is for her to report as directed, payments of $30 bi-weekly, community services 6 hours per week, zero tolerance for 120 days. The next report date would be on March 17th, 2023. Due to the defendant not being arrested and her advising probation of the new citation, Judge, that's why we did not recommend any jail time.
Good. I was hoping you had self-reported.
Yeah, of course.
I respond very favorably to that. Okay. Do you admit to the violation?
Yes.
And is that recommendation acceptable?
Yes.
Okay, I agree as well. And I appreciate you being transparent with us and letting us know what's going on. You also will have that new court date coming up soon. It probably hasn't been filed with us yet.
I already took care of it.
Oh, you've already taken care of it?
To some in this location,
Oh,
yes, she's
okay.
already been sentenced.
Perfect. Great. Well then, Ms. Gaddis, good luck to you. If you will step back through the double doors there and wait by the hand sanitizer dispenser, they also have you sign your order, and they will give you a copy before you leave. William Gregory. All right, do you both, just raise your hand, do you both solemnly swear or affirm the testimony about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
I do.
All right, you both sworn. Say your full name for me.
William Blake Gregory.
Mr. Gregory, you are here on 22 TK 2993. According to, you understand that you're here today because your probation officer filed paperwork with me alleging that you're out of compliance with your probation.
Yes, sir.
You have the right to have an attorney represent you, and you're here representing yourself. Is that okay with you?
Yes, sir.
All right, Ms. Matthews, floor is yours.
Judge, on 22 TK 2993, the defendant is alleged to have violated the terms and conditions of probation in the following. The defendant failed to report to probation as ordered, having missed 4 of 14 appointments. The defendant failed to pay the fines and fees as ordered, or utilize community service work in lieu of the court fine, being in arrears $205. The recommendation on this case is for him to report to probation as directed, payments of $97 bi-weekly, zero tolerance for 90 days. His next report date would be tomorrow, March 17th, between 9 and noon, or 1 to 6.
All right, 2 questions. Do you admit to the violation?
Correct.
And is that recommendation acceptable?
Yes, sir. I only have one question. Is it still a phone call, or do I need to be in there to report?
I believe it is report until completion. So it's right, she's back to this.
So I have another
Hold
question.
on, I'm asking.
Oh.
I'm asking what the recommendation was on.
I would be willing to do for him to report in person until he gets his case back into
I'm
compliance.
great with that. That's what I was thinking it was.
Okay,
So
that's
you're
fine.
reporting in person until you get it back on track.
Right, I'll have that back. I can go pay it now, but I'm behind. And my other second question is I've already asked if my driver's license was suspended out of another county. So, but one of my recommendations was for me to get my license back, but I've already offered to pay my fines off and just be done with Spalding County. But I was told no, but I can't do anything because the state of Georgia is holding my license.
Well, what's got your license in the other county?
The DUI.
When is your license gonna be reinstated?
May 20th is when they release them.
Of this year?
Yes, sir.
Okay. Yeah, I mean, I'm gonna let you go back on phone report, but I really need you to get that license back, so.
Yeah, I can't do nothing to it. The state of Georgia releases them.
Yeah, we're in this for the next 60 days then, but I'm gonna let you get me on phone report, okay?
Awesome. Appreciate it.
Well, once you get your case back on track, I should be very careful. You'll go back to phone report once you get your case back on track.
Awesome. Thank
All
you.
right, thank you. You'll wait by the door. All right, that was Gregory. Next case is Taylor. All right, y'all both raise your right hands. You solemnly swear or affirm testimony about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, take your hand down. State your full name for me.
Jeremy Dean Kaler Sr.
All right, Mr. Kaler, you're here on 21 SR 1618 because your probation officers filed paperwork with the clerk of court alleging that you're out of compliance with your probation. You understand what you're doing here today? You have the right to have an attorney represent you, and you're here representing yourself. Is that okay with you?
Yes, sir.
All right. Go ahead, Ms. Matthews.
Judge, on 21 SR 1618, the defendant is alleged to have violated the terms and conditions of probation in the following. The defendant failed to obey the criminal laws of any governmental unit as ordered by the new charges of suspended registration, no proof of insurance, failure to update address, being committed on or about February 5th, 2023, in or around Spalding County, Georgia. The recommendation on this case is to report to probation as directed, payments of $118 monthly, zero tolerance for 120 days, to continue to attend his family violence intervention classes weekly. His next report date would be tomorrow, March 17th, 2023. Again, Judge, he advised us of the new charges, therefore we're not asking for any jail time.
Okay, good job on that. All right, Mr. Kaler, do you admit to the violation?
Well, I haven't been to court on the violations yet, so I don't know.
Let me be a little more careful.
Okay.
I'm not asking you to admit guilt on the new charge.
Okay.
I'm asking you if you violated your probation with the new charge.
With the ticket.
It's a different standard, and
Yes,
it can't be used against you in the main case.
Yes.
Is that acceptable?
Yes, sir.
Okay. So you're admitting to that? All right, that sounds fine. And is that recommendation acceptable?
Yes. And I also had another run-in with law enforcement. I hit a deer, so I don't know if I need to report that.
Did you get a ticket there?
No, I didn't. I just had to call and report on my insurance. So.
Yeah, that's fine. I'm okay with that.
Okay.
We're looking for tickets.
Okay.
And again, you self-reported here, so
Yes,
good
sir.
job. That's
Yes,
what we're looking for. All right, if you'll step over to the light switch there,
Thank you.
Vanessa will get you to sign your order.
So I report tomorrow?
Yes.
Okay, thank you.
It'll be on your paper. Go back through that door. Go back through the doors.
Okay, thank you.
Kelso? All right, y'all both raise your right hands. You solemnly swear or affirm testimony about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
I do.
All right, state your full name for me.
Jared Kelso.
Mr. Kelso, you're here on 21 SR 842 because your probation officers filed paperwork with the clerk of this court alleging that you are out of compliance with your probation. You understand what you're doing here today?
Yes, sir.
You have the right to have an attorney represent you, and you're here currently representing yourself. Is that what you want to do?
Yes, sir.
You ready to go forward?
Yes, sir.
Matthews, floor is yours.
Judge, on 21 SR 842, the defendant is alleged to have violated the terms and conditions of probation in the following. The defendant failed to provide proof of obtaining a Class C driver's license by the extended deadline of January 6, 2023. The defendant failed to provide proof of attending ASAM Level 1 classes by the deadline of December 15, 2022. The recommendation on this case is for him to report to probation as directed, payments of $74 bi-weekly, attend ASAM classes weekly without interruptions and provide proof, zero tolerance for 90 days, obtain his driver's license by May 15, 2023. His next report date would be in person tomorrow, March 17th, between 9 and noon or 1 to 6.
All right, Mr. Kelso, you admit to the violations?
Yes, sir. But I mean, Judge Thacker, the reason I haven't been able to get my license on time is because the class that I was taking, I worked 2 jobs because I paid $1,200 a month in child support, as well as felony and misdemeanor probation as well. So due to all the financial status and the hours that I have to work, because I'm a restaurant kitchen manager for Southern Pitt,
and I'm a construction worker also for 3 days a week. So I work 7 days a week. But I was signed up for an ASAM level 1 class after the initial clinical evaluation that was given on the north side. I forgot the name of the
Prior to Mars?
It's on the north side by the old Griffin Animal Vet.
It's prior to Mars.
But I actually missed a few of the phone calls, and my program got terminated by the counselor. So, and then after that, I've actually repaid for another ASAM level 1 class, and I've also actually repaid for another clinical evaluation. And now I just have to go to my classes to get them done now.
Good.
And I have that signed up on every Tuesday for the next 12 weeks.
Well, I really appreciate you putting those efforts in.
Well, Judge Thacker, what I also wanted to ask was due to my the only reason I have a vehicle right now because of all the financial status. My boss bought me a 2012 Jeep Patriot. I am currently paying my boss back off of the record, off of the books, to own that title to be wrote to me from my boss at Southern Bid. Sean Gregory, that's my boss.
Okay.
But I have my driver service records for my what is it called? My detailed suspension report. I have all my detailed suspension reports. I had given them to the probation office as well. So
It says you.
what I'm asking for is a waiver.
Well, it can't. That's why I have it, because if I was already ahead of you, if I could have issued a waiver, I would have. But this is not. All you've got to do to get your license back is a risk reduction course.
There's an interlock on there, Judge.
There's an interlock.
But we called him on Monday or Tuesday, told him to call state court to get on the calendar today for you to review his case to do an interlock waiver while he was already gonna be here. And based off of Erica's calendar, I don't see, we provided him all the information in order to be able to make this a smooth transition.
Well, I understand that, Ms. Matthews. I had y'all.
We were trying to help you.
Yes, ma'am, you did, and you did. I agree with that. I just, I'm so busy. I've been extremely busy doing all this stuff that I've been doing, and I've been on probation for 6 years. So I'm.
Make a copy of this page. All right, I'll take that under advisement. So, all right, I'm taking that part under advisement. If I choose to give it, I'll give it to Ms. Matthews, and you'll have it. You didn't do it the right way, but you're kind of close. All right, anything else?
No, that's pretty much it. Just,
I'll consider.
what is the dollar amount on my probation? Because I actually only owed $100 on my probation.
That's not information I have, but you can get it tomorrow when you report to probation.
But I don't get fees added to my probation.
I'm saying I don't know, and I'm saying you'll get that number tomorrow when you report to probation.
That'll work. Thank you, Judge.
And like I said, if I decide to bend my own rules and give you that interlock waiver, I'll give it to Ms. Matthews.
Thank you, sir.
All right, you may go step over by the light switch. Maynard? All right, you are Andrea Maynard?
Yes, sir.
All right, y'all both please raise your right hands. You solemnly swear or affirm testimony about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
I do.
All right. State your full name, please.
Andrea Jeanette Maynard.
Ms. Maynard, you're here on 22 SR 1444 because your probation officer has filed paperwork with the clerk of this court alleging that you are out of compliance with your probation. Do you understand what you're doing here today?
Yes, sir.
And you have the right to have an attorney represent you, and you're here representing yourself.
Yes, sir.
Is that what you want to do?
Yes, sir.
All right, you ready to go forward?
Yep.
All right, so
Judge, on 21 SR 1444, the defendant is alleged to have violated the terms and conditions of probation the following. The defendant failed to avoid injurious and vicious habits by testing positive for marijuana on or about January 27, 2023 in the JAG probation office. The recommendation on this case is 2 weekends in jail on March 24th and March 31st, beginning at 5 p.m. To report to probation as directed, payments of $80 bi-weekly, zero tolerance for 90 days, a substance abuse evaluation, a new one to be completed within 30 days, and follow any recommendations. The next report date would be in person tomorrow, March 17th, between 9 and noon, or 1 to 6.
All right, Mr. Maynard, 2 questions. Do you admit to the violation?
Yes, sir.
And is that recommendation acceptable?
What she said, 2 weekends?
2 weekends. That's kind of my standard response to this.
Okay, yes, that's fine.
All right, then I'm gonna say that that is an appropriate recommendation. And I think that's a good response. So, all right, do you have any questions for me, Matt?
No, sir.
All right, if you'll step back through those double doors, wait over by the light switch there. Bailiffs will bring you a copy of your order to sign. McMullen. All right, please raise your right hands. Do you solemnly swear or affirm testimony about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
I do.
All right, take your hand down, say your full name.
Jesse James McMullen.
Mr. McMullen, you're here on 21 SR 939 because your probation officers filed paperwork with the clerk of this court alleging that you were out of compliance with your probation. Do you understand what you're doing here today?
Yes, sir.
You have the right to have an attorney represent you, and you're here representing yourself. Is that what you want to do?
Yes, sir.
You ready to go forward?
Yes, sir.
All right, floor is yours.
Judge, on 21 SR 0939, the defendant is alleged to have violated the terms and conditions of probation the following. The defendant failed to pay the fees as ordered, being in arrears $60. The defendant failed to provide proof of completing court-ordered fine conversion hours by turning in 0 out of 47 hours as of the date the petition was drafted. The recommendation on this case is for him to report to probation weekly for the duration, payments of $40 weekly, community service at 15 hours per week, 0 tolerance for the duration of active probation. His next report date would be tomorrow, March 17th, between 9 and noon, or 1 to 6.
All right, Mr. McMullen, 2 questions. Number 1, do you admit to the violations?
Yes, sir. I got the paper in my pocket while showing I did a community service. I turned it in. I couldn't turn it in that following week they wanted because I had COVID. I was sick. So I got the paper right here.
So you turned it in after March 6th?
I just turned it in last week. I got the paper right here.
And are you behind? Were you behind on March 6th with your community service work? I'm sorry, let me ask a different question. On March 6th, which is the date this was created, and you turned in those hours?
Oh, yeah, I had turned it in. I turned 23 hours in, and plus I got 10 more hours.
Okay, well then this is a contested hearing. I will make my own decision as to whether or not you violated your probation based off of the evidence received. At this point, Ms. Matthews, I need you to please take a look at your file and testify as to whether or not he was in arrears of $60 on March 6th, and whether or not he had provided any hours of his community service work by March 6th.
Yes, Judge. So his fees are added on the 2nd of every month, and his probation fees for the $60 is going to be a slight arrears from the month of February because he just paid $40, and then his fees were added on the 2nd for the next month. There's where he came in arrears of $60. The last payment that's been made on this case was on February the 28th, and that's current information as of right this moment, Judge. Mr. McMullen accepted the community service on February the 2nd. He appeared in our office this week, 3 days ago, on March the 13th. At that time is when he turned in 22 of the 47 hours. Again, I believe that was Monday. So before Monday, we had no hours of community service.
All right, Mr. McMullen, does that sound correct to you, or does that sound incorrect?
I hadn't turned it in, but when I called in on the Wednesday, and I told them how many hours I had, so I didn't know I was supposed to take it up there to them that same week or something. But I told them I had 23 hours then.
Okay.
And so, and then I got 10 more.
All right. Do you want to ask Ms. Matthews any questions?
No, sir.
Okay. Ms. Matthews, anything else you want me to know?
No, sir.
All right. Mr. McMullen, anything else you want me to know?
No, sir.
All right. All right. Well, I find that there is sufficient evidence for me to find that he is willfully out of compliance with his probation. Although he is less out of compliance today than he was on the date of the allegations. I think this is a communication issue and not an outright denial, so I'm gonna follow the recommendation. All right, any questions, Mr. McMullen?
No, sir.
All right, then, if you will step over by the light switch, keep doing your hours, keep getting those turned in, keep getting the case back on track, okay?
Yes, sir.
All right, thank you. Miller? All right, raise your right hand. Solemnly swear or affirm testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
I do.
All right, state your full name for me.
President Keith Miller.
Mr. Miller, you're here on 21 SR 2627. Is your probation officers filed paperwork with the clerk of this court alleging that you're out of compliance with your probation? You understand what you're doing here today?
Yes, sir.
You have the right to have an attorney represent you, and you're here representing yourself. Is that what you want to do?
Yes, sir.
You ready?
Yes, sir.
All right.
Judge, on 21 SR 2627, the defendant is alleged to have violated the terms and conditions of probation and the following. The defendant failed to pay the fines and fees as ordered, being in arrears $777. The defendant failed to provide proof of completing court-ordered community service hours by turning in 15 of 40 court-ordered hours. The defendant has failed to provide proof of completing court-ordered DUI school by the extended deadline of January 30th, 2023. The defendant has failed to provide proof of completing a court-ordered substance abuse evaluation by the extended deadline of February 1st of 2023. The recommendation on this case is to report to probation as directed, payments of $210 bi-weekly, community service at a minimum rate of 8 hours per week, zero tolerance for the duration of active probation, to complete a substance abuse evaluation within 30 days and follow all recommendations, to complete DUI school within 90 days. His next report date would be in person tomorrow, March 17th, between 9 and noon, or 1 to 6.
All right, Mr. Miller, 2 questions. Do you admit to the violations?
Yes, sir.
And is that recommendation acceptable?
Yes, sir. But the $210 a week, I ain't gonna be able to do that. I just got a job, and my reason for being behind is because I had 2 surgeries. One October the 18th on my knee, then I had to turn around and have one November the 3rd. So I've been out of work for like 6 months.
You provided that paperwork?
Yes, sir.
Okay. So what we'll do is when you meet tomorrow with probation, we're very rarely a cash-only court. And so unless it's restitution, we usually are successful at finding different ways for folks to be able to check their boxes.
Yes, sir.
So I want you to talk to your probation officer tomorrow, and I want you all to explore ways for you to check this box without having to pull cash out of your pocket, okay?
Yes, sir.
All right, so I'm gonna leave it as it is, but that's because my court automatically gives you options, all
Yes,
right?
sir.
Does that answer your question?
Yes, sir.
All right, so don't panic, just pivot, okay?
Yes,
All right, that's it, then I'm gonna follow the recommendation. If you have any other questions, I'm happy to answer them.
I'm good, sir.
All right, well, if you'll step back through the double doors behind you, take a left and wait by the light switch. Go ahead and sign the order, and they'll get you moving in the direction. All right, somebody was late. Is that you? Come on up. Who are you?
Freeman.
She was doing the lawyer was here for.
Oh, okay. This is Freeman.
Yes, sir.
All right, Ms. Freeman, Ms. Matthews, y'all both please raise your right hands. You solemnly swear or affirm the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
I do.
All right, say your full name for me.
Adrienne Nicole Freeman.
All right, Ms. Freeman, you are here today on 21 SR 2392 because you're participating in our pretrial diversion program, and your supervising officer has filed paperwork with me alleging that you're out of compliance with the pretrial diversion program. You understand what you're doing here today? I have 2 options on the table. I have 2 questions on the table. I need to decide whether or not you violated the contract, and then I need to decide whether to leave you in the program or take you out. You understand those are the questions for me to answer on the table today?
Yes.
You ready to go forward?
Yes, sir.
All right. Ms. Matthews, floor is yours.
Judge, on 21 SR 2392, the defendant is alleged to have violated the terms of the pretrial diversion sentence in the following. The defendants failed to report to probation as ordered, having missed 4 of 10 scheduled appointments. The defendants failed to pay the fines and fees as ordered, or utilize community service work in lieu of the court fine, being in arrears $360. Judge, prior to her being late, we were willing to restore her back to probation. I'm going to defer to the court to whether you would like to keep her in the pretrial diversion program or not.
Yeah, why are we late?
I can, there's a few times where she told me the date and we got just miscommunicated. So,
Okay. Anything else you want me to know?
I'm gonna take care of the fees tomorrow, next week. They should be taken care of by next week.
All right. Add 8 hours for being late to court. Otherwise, I'll follow the recommendation.
Yes, Judge.
All right. So I'm adding 8 hours of community service work for being late to court.
Okay.
And you're going to meet with your probation officer tomorrow, and y'all are going to get a roadmap to get this case closed because it is a terminate upon completion case. And you have every ability to get this case closed and put this in your rearview mirror.
Right.
Okay? Any questions?
You said tomorrow, right?
Yeah, you're going to report to probation tomorrow between 9 and noon or 1 and 6.
Okay. Because it's usually over the phone, so I need to go in.
Yeah, you're going to be in person until you get your case closed. Because you're not that far off from getting it closed.
Right.
So I want you highly motivated to check your boxes. All right. Any other questions?
Yes, sir.
All right. If you'll wait over there, go back behind you through the double doors, and then wait over by the light switch. All right. And then all right.
You already signed this one, Judge.
All right, Ms. Chamberlain, you there?
Yes, I am.
Okay. Okay, there we go. All right, Ms. Chamberlain, you were given permission to report virtually. And you're here today on 19 SR 1574 because your probation officers filed paperwork with the clerk of this court alleging that you were out of compliance with your probation. Do you understand why we're having this hearing?
Yes.
Is it acceptable to you that we are having this hearing over this video conference system?
Yes.
You have the right to have an attorney represent you, and you're here representing yourself. Is that acceptable to you?
Yes.
Okay. All right, Ms. Matthews, floor is yours.
Judge, on 19 SR 1574, the defendant is alleged to have violated the terms and conditions of probation the following. The defendant failed to pay the fees as ordered, being in arrears $337.50. The recommendation on this case is for her to report to probation weekly until a full compliance. Payments of $68 per week, $0 for the duration of active probation. The next report date would be by phone on March 29th, 2023, between 9 and noon or 1 to 4.
All right. Ms. Chamberlain, I have 2 questions for you. Do you admit to the violation?
Yes.
And is that recommendation acceptable?
Not really.
Okay. What is it you are looking for from me?
I would like you to waive the probation fees, because from my understanding, my current probation officer, Mr. Rodriguez, she said if I don't have any bills in my name, therefore I would not meet the requirements to have my probation fees waived. She said that's why I had to go in front of you.
Well, they need you to provide them with your financials to review. Have you done that?
No.
Okay, because usually those questions actually don't make it to me much, because usually once you provide that to probation, they usually take care of it by just emailing me an order. So,
okay.
So you need to provide them with what they're asking you for, and you will very likely get what you want, but I'm not going to give it to you now because you haven't given them the paperwork to make that decision.
Can I explain why? And
well, I mean, there's no need for you to explain why, because there's no scenario where we end that conversation and I do what you want at this moment. But I'm telling you right now that if you'll do that, you will very likely get what you want. You just need to start tomorrow, whatever the report date, the 29th, Get them what they need, and then you'll very likely get what you want.
Okay, Judge Thacker, I can't provide them what they need because I don't have a job. I'm borderline homeless. I don't have a lease in my name. I don't have a water bill, phone bill, power bill in my name. And
Well,
that's what she was saying that she needs.
right. Do you receive Social Security disability or Social
Yes,
Security?
yes.
Well, that's what they're looking for.
Oh, okay.
Yeah. So we're good. Like I said, I'm not worried about you, Miss Chamberlain. You're not on my list of people to worry about. You just get that paperwork
Okay.
in, and you're
All
gonna be
right,
all
I
right.
sure
Okay.
will.
Yeah. They just need the Social Security information.
All right, thank you.
Do you have any other questions for me, ma'am?
No, I don't. Thank you.
Okay. So get the monthly Social Security statement you get. Just send it to them. Okay.
All right.
All right. Thank you, Miss Chamberlain. Let's get that checked off and get this off your list of things to worry about. Okay.
All right, thank you so much.
All right. Thank you.
Bye-bye.
And then whoever the phone call was is gone. So
He was up there for a while, and he just disconnected.
disappeared. So Kevin Bowles, 22 TK 1442. I never spoke to whoever calling user was. And they're gone without permission, and there's nobody else in the courtroom, so Kevin Bowles is the one. Because I have no confirmation that the phone call person was Kevin Bowles. He's welcome to try to get his case back on track. All right. Then I'm going to say anything else. It's 12:49. Great job with a very difficult day, everybody. And court is adjourned.